Draft version 1.
American Apologetics. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris. Bafou.
Two, in drawing this critical distinction between the abortion right and other rights, it is not necessary to dispute Casey's claim, which we accept for the sake of argument, that the specific practices of states at the time of the adoption of the 14th Amendment do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. Abortion is nothing new. It has been addressed by lawmakers for centuries, and the fundamental moral question that it poses is ageless. Defenders of Roe and Casey do not claim that any new scientific learning calls for a different answer to the underlying moral question, but they do contend that changes in society require the recognition of a constitutional right to obtain an abortion. Without the availability of abortion, they maintain, people will be inhibited from exercising their freedom to choose the types of relationships they desire, and women will be unable to compete with men in the workplace and in other endeavors. Americans who believe that abortion should be restricted press countervailing arguments about modern developments. They note that attitudes about the pregnancy of unmarried women have changed drastically, that federal and state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases, that the costs of medical care associated with pregnancy are covered by insurance or government assistance, that states have increasingly adopted safe haven laws, which generally allow women to drop off babies anonymously, and that a woman who puts her newborn up for adoption today has little reason to fear that the baby will not find a suitable home. They also claim that many people now have a new appreciation of fetal life and that when prospective parents who want to have a child view a sonogram, they typically have no doubt that what they see is their daughter or son. Both sides make important policy arguments, but supporters of Roe and Casey must show that this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and we thus return the power to weigh those arguments to the people and their elected representatives. 3. We next consider whether the doctrine of stare decisis counsels continued acceptance of Roe and Casey. Stare decisis plays an important role in our case law, and we have explained that it serves many valuable ends. It protects the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expense of endless relitigation. It fosters even-handed decision-making by requiring that like cases be decided in a like manner. It contributes to the actual and perceived integrity of the judicial process. And it restrains judicial hubris and reminds us to respect the judgment of those who grappled with important questions in the past. Precedent is a way of accumulating and passing down the learning of past generations, a font of established wisdom richer than what can be found in any single judge or panel of judges. We have long recognized, however, that stare decisis is not an inexorable command, Pearson v. Callahan, and it is at its weakest when we interpret the Constitution, Agostini v. Felton, 521 U.S. 203, 235, 1997. It has been said that it is sometimes more important that an issue be settled than that it be settled right. But when it comes to the interpretation of the Constitution, the great charter of our liberties, which was meant to endure through a long lapse of ages, Martin v. Hunter's Lessee, 1 Wheat. 304, 326, 1816, Opinion of Story, J. We place a high value on having the matter settled right. In addition, when one of our constitutional decisions goes astray, the country is usually stuck with the bad decision unless we correct our own mistake. An erroneous constitutional decision can be fixed by amending the Constitution, but our Constitution is notoriously hard to amend. Therefore, in appropriate circumstances, we must be willing to reconsider and, if necessary, overrule constitutional decisions. Some of our most important constitutional decisions have overruled prior precedents. We mention 3. In Brown v. Board of Education, the court repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities. 347 U.S. 483, 488, 1954. In so doing, the court overruled the infamous decision in Plessy v. Ferguson, 163 U.S. 537, 1896, along with 6 other Supreme Court precedents that had applied the separate but equal rule. C. Brown, 347 U.S. at 491. In West Coast Hotel Company v. Parrish, 300 U.S. 379, 1937, the court overruled Adkins v. Children's Hospital of D.C., 261 U.S. 525, 1923, which had held that a law setting minimum wages for women violated the liberty protected by the Fifth Amendment's Due Process Clause. A.D. at 545. West Coast Hotel signaled the demise of an entire line of important precedents that had protected an individual liberty right against state and federal health and welfare legislation. C. Lochner v. New York, 198 U.S. 45, 1905, holding invalid a law setting maximum working hours. Coppage v. Kansas, 236 U.S. 1, 1915, holding invalid a law banning contracts forbidding employees to join union. J. Burns Baking Company v. Bryan, 264 U.S. 504, 1924, holding invalid laws fixing the weight of loaves of bread. Finally, in West Virginia Board of Education v. Barnett, 319 U.S. 624, 1943, after the lapse of only 3 years, the court overruled Minersville School v. Gobitis, 310 U.S. 586, 1940, and held that public school students could not be compelled to salute the flag in violation of their sincere beliefs. Barnett stands out because nothing had changed during the intervening period other than the court's belated recognition that its earlier decision had been seriously wrong. On many other occasions, this court has overruled important constitutional decisions. We include a partial list in the footnote that follows. Without these decisions, American constitutional law as we know it would be unrecognizable, and this would be a different country. No justice of this court has ever argued that the court should never overrule a constitutional decision, but overruling a precedent is a serious matter. It is not a step that should be taken lightly. Our cases have attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making such a decision. In this case, 5 factors weigh strongly in favor of overruling Roe and Casey: the nature of their error, the quality of their reasoning, the workability of the rules they imposed on the country, their disruptive effect on other areas of the law, and the absence of concrete reliance. A. The nature of the court's error. An erroneous interpretation of the Constitution is always important, but some are more damaging than others. The infamous decision in Plessy v. Ferguson, Supra, was one such decision. It betrayed our commitment to equality under law. It was egregiously wrong on the day it was decided, and as the Solicitor General agreed at oral argument, it should have been overruled at the earliest opportunity. Roe was also egregiously wrong and deeply damaging. For reasons already explained, Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. Roe was on a collision course with the Constitution from the day it was decided, and Casey perpetuated its errors, and the errors do not concern some arcane corner of the law of little importance to the American people. Rather, wielding nothing but raw judicial power, Roe, 410 U.S. at 222, Justice White, dissenting. The court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. Roe fanned into life an issue that has inflamed our national politics in general, and has obscured with its smoke the selection of justices to this court in particular ever since. Casey, 505, U.S. at 995 to 996. Together, Roe and Casey represent an error that cannot be allowed to stand. As the court's landmark decision in West Coast Hotel illustrates, the court has previously overruled decisions that wrongly removed an issue from the people and the democratic process. As Justice White later explained, decisions that find in the Constitution principles or values that cannot fairly be read into that document usurp the people's authority, for such decisions represent choices that the people have never made and that they cannot disavow through corrective legislation. For this reason, it is essential that this court maintain the power to restore authority to its proper possessors by correcting constitutional decisions that, on reconsideration, are found to be mistaken. B. The quality of the reasoning. Under our precedents, the quality of the reasoning in a prior case has an important bearing on whether it should be reconsidered. In Part 2 of this opinion, we explained why Roe was incorrectly decided, but that decision was more than just wrong. It stood on exceptionally weak grounds. Roe found that the Constitution implicitly conferred a right to obtain an abortion, but it failed to ground its decision in text, history, or precedent. It relied on an erroneous historical narrative. It devoted great attention to and presumably relied on matters that have no bearing on the meaning of the Constitution. It disregarded the fundamental difference between the precedents on which it relied and the question before the court. It concocted an elaborate set of rules, with different restrictions for each trimester of pregnancy, but it did not explain how this veritable code could be teased out of anything in the Constitution, the history of abortion laws, prior precedent, or any other cited source. And its most important rule, that states cannot protect fetal life prior to viability, was never raised by any party and has never been plausibly explained. Roe's reasoning quickly drew scathing scholarly criticism, even from supporters of broad access to abortion. The Casey plurality, while reaffirming Roe's central holding, pointedly refrained from endorsing most of its reasoning. It revised the textual basis for the abortion right, silently abandoned Roe's erroneous historical narrative, and jettisoned the trimester framework. But it replaced that scheme with an arbitrary undue burden test and relied on an exceptional version of stare decisis that, as explained below, this court had never before applied and has never invoked since. 1. The weaknesses in Roe's reasoning are well known. Without any grounding in the constitutional text, history, or precedent, it imposed on the entire country a detailed set of rules much like those that one might expect to find in a statute or regulation. See Roe, 410 U.S. at 163 to 164. Dividing pregnancy into 3 trimesters, the court imposed special rules for each. During the first trimester, the court announced the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. After that point, a state's interest in regulating abortion for the sake of a woman's health became compelling, and accordingly, a state could regulate the abortion procedure in ways that are reasonably related to maternal health. Finally, in the stage subsequent to viability, which in 1973 roughly coincided with the beginning of the third trimester, the state's interest in the potentiality of human life became compelling, and therefore a state could regulate, and even proscribe, abortion except where it is necessary, in appropriate medical judgment, for the preservation of the life or health of the mother. This elaborate scheme was the court's own brainchild. Neither party advocated the trimester framework, nor did either party or any amicus argue that viability should mark the point at which the scope of the abortion right and a state's regulatory authority should be substantially transformed. 2. Not only did this scheme resemble the work of a legislature, but the court made little effort to explain how these rules could be deduced from any of the sources on which constitutional decisions are usually based. We have already discussed Roe's treatment of constitutional text, and the opinion failed to show that history, precedent, or any other cited source supported its scheme. Roe featured a lengthy survey of history, but much of its discussion was irrelevant, and the court made no effort to explain why it was included. For example, multiple paragraphs were devoted to an account of the views and practices of ancient civilizations where infanticide was widely accepted. See Roe 410 U.S. at 130 to 132, discussing ancient Greek and Roman practices. When it came to the most important historical fact, how the states regulated abortion when the 14th Amendment was adopted, the court said almost nothing. It allowed that states had tightened their abortion laws in the middle and late 19th century, Edom at 139, but it implied that these laws might have been enacted, not to protect fetal life, but to further a Victorian social concern about illicit sexual conduct, Edom at 148. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what it said about the common law was simply wrong. Relying on two discredited articles by an abortion advocate, the court erroneously suggested, contrary to Bracton, Koch, Hale, Blackstone, and a wealth of other authority, that the common law had probably never really treated post-quickening abortion as a crime. See Edom at 136. It now appears doubtful that abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. This erroneous understanding appears to have played an important part in the court's thinking because the opinion cited the lenity of the common law as one of the four factors that informed its decision. After surveying history, the opinion spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee. This included a lengthy account of the position of the American Medical Association and the position of the American Public Health Association, as well as the vote by the American Bar Association's House of Delegates in February 1972 on proposed abortion legislation. Also noted were a British judicial decision handed down in 1939 and a new British abortion law enacted in 1967. The court did not explain why these sources shed light on the meaning of the Constitution, and not one of them adopted or advocated anything like the scheme that Roe imposed on the country. Finally, after all this, the court turned to precedent. Citing a broad array of cases, the court found support for a constitutional right of personal privacy, but it conflated two very different meanings of the term: the right to shield information from disclosure and the right to make and implement important personal decisions without governmental interference. Only the cases involving this second sense of the term could have any possible relevance to the abortion issue, and some of the cases in that category involved personal decisions that were obviously very, very far afield. C. Pierce v. Society of Sisters, 268, U.S. 510, 1925. Right to send children to religious school, Meyer v. Nebraska, 262, U.S. 390, 1937. Right to have children receive German language instruction. What remained was a handful of cases having something to do with marriage, Loving v. Virginia, 388, U.S. 1, 1967. Right to marry a person of a different race, or procreation, Skinner v. Oklahoma, 316, U.S. 535, 1942. Right not to be sterilized, Griswold v. Connecticut, 381, U.S. 479, 1965. Right of married persons to obtain contraceptives, Eisenstadt v. Baird, 405, U.S. 438, 1972. Same for unmarried persons. But none of these decisions involved what is distinctive about abortion, its effect on what Roe termed potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with the following: 1. The relative weights of the respective interests involved. 2. The lessons and examples of medical and legal history. 3. The lenity of the common law. And 4. The demands of the profound problems of the present day. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. 3. What Roe did not provide was any cogent justification for the lines it drew. Why, for example, does a state have no authority to regulate first trimester abortions for the purpose of protecting a woman's health? The court's only explanation was that mortality rates for abortion at that stage were lower than the mortality rates for childbirth. But the court did not explain why mortality rates were the only factor that a state could legitimately consider. Many health and safety regulations aim to avoid adverse health consequences short of death. And the court did not explain why it departed from the normal rule that courts defer to the judgments of legislatures in areas fraught with medical and scientific uncertainties. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. Here is the court's entire explanation. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the womb. Roe, 410, U.S., at 163. As Professor Lawrence Tribe has written, clearly, this mistakes a definition for a syllogism. The definition of a viable fetus is one that is capable of surviving outside the womb. But why is this the point at which the state's interest becomes compelling? If, as Roe held, a state's interest in protecting prenatal life is compelling after viability, 410 U.S. at 163, why isn't that interest equally compelling before viability? Webster v. Reproductive Health Services, 492, U.S. 490, 519, 1989, plurality. Quoting Thornburg v. American College of Obstetricians and Gynecologists, 476, U.S. 747, 795, 1986, Justice White, dissenting. Roe did not say, and no explanation is apparent. This arbitrary line has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. Some have argued that a fetus should not be entitled to legal protection until it acquires the characteristics that they regard as defining what it means to be a person. Among the characteristics that have been offered as essential attributes of personhood are sentience, self-awareness, the ability to reason, or some combination thereof. By this logic, it would be an open question whether even born individuals, including young children or those afflicted with certain developmental or medical conditions, merit protection as persons. But even if one takes the view that personhood begins when a certain attribute or combination of attributes is acquired, it is very hard to see why viability should mark the point where personhood begins. The most obvious problem with any such argument is that viability is heavily dependent on factors that have nothing to do with the characteristics of a fetus. One is the state of neonatal care at a particular point in time. Due to the development of new equipment and improved practices, the viability line has changed over the years. In the 19th century, a fetus may not have been viable until 32 or 33 weeks after conception or even later. When Roe was decided, viability was gauged at roughly 28 weeks. Today, respondents draw the line at 23 or 24 weeks. So, according to Roe's logic, states now have a compelling interest in protecting a fetus with a gestational age of, say, 26 weeks. But in 1973, states did not have an interest in protecting an identical fetus. How can that be? Viability also depends on the quality of the available medical facilities. Colautti v. Franklin, 439 U.S. 379, 396, 1979. Thus, a 24-week-old fetus may be viable if a woman gives birth in a city with hospitals that provide advanced care for very premature babies. But if the woman travels to a remote area far from any such hospital, the fetus may no longer be viable. On what ground could the constitutional status of a fetus depend on the pregnant woman's location? And if viability is meant to mark a line having universal moral significance, can it be that a fetus that is viable in a big city in the United States has a privileged moral status not enjoyed by an identical fetus in a remote area of a poor country? In addition, as the court once explained, viability is not really a hard and fast line. Colautti, 439 U.S. at 396. A physician determining a particular fetus's odds of surviving outside the womb must consider a number of variables, including gestational age, fetal weight, a woman's general health and nutrition, the quality of the available medical facilities, and other factors. It is thus only with difficulty that a physician can estimate the probability of a particular fetus's survival. And even if each fetus's probability of survival could be ascertained with certainty, settling on a probability of survival that should count as viability is another matter. Is a fetus viable with a 10% chance of survival? 25%? 50%? Can such a judgment be made by a state? And can a state specify a gestational age limit that applies in all cases? Or must these difficult questions be left entirely to the individual attending physician on the particular facts of the case before him? The viability line, which Casey termed Roe's central rule, makes no sense, and it is telling that other countries almost uniformly eschew such a line. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of Western democracies enjoy.
Bafou. American apologetic. A perusal of Dobbs v. Jackson. Leaked abortion case. Written and produced by Pacificatoris.
To be continued.